So welcome all of you to our EB-5 seminar. This is a professional event. It's intended for people who are professionals in the EB-5 industry. It is not intended for investors. Just keep that in mind. But despite all of that, we are all in the United States. So I'm going to, we are bound by American law, all of us here. And therefore, I'm going to read out our usual disclaimer. Nothing you hear today is legal advice. Nothing you hear today is financial advice. Everything is educational. And the idea is that information is power. We would like you to get as much information as you can from from our speakers today and learn such things as you can from them to be able to use in your practices and your businesses in the EB-5 industry. We have well over 100 people registered. We've been having a huge number of people actually attend, not just register. That's a huge percentage, almost 75%. So you're all welcome. And that's one of the reasons why, if you don't register your question early enough, I'm not sure I can get to it. So please do register your question when you get a chance. The sequence and structure of the event is very, very simple. I'm going to finish my introduction momentarily. We're going to have a quick 30-second advertising break, and then we're going to jump into learning from Kate Kalmykov and Mark Katzoff, both of whom are long-timers in the EB-5 industry, well known to all of you. We have circulated their bios before, and we'll surely send to everybody attending their contact information so that you can follow up with them for any issues professionally that you may want to do so. And that brings us to the advertising break. I'm going to invite my colleague Shrikant to please for a 30-second advertising break. Please take it away.
Thanks, Sam. We are noticing a significant pent-up demand for EB-5 from reports of multiple agents from multiple countries, as well as our own events here in the USA. We have events coming up in Mumbai, Kuwait, Phoenix, and Atlanta between May 19th and May 22nd. To exhibit and speak at these events, you can reach us at webmaster@ilw.com. Thank you.
Thank you, Shrikant. And now let's just plunge in. Let me begin with Kate. USCIS has created this new concept of redesignation, I believe is the term they use. Some people say recertification. And they're talking about the need for new filings. What's all this stuff about? Can you please tell us about designation of existing RCs and the need for new filings, please?
Well, it is quite confusing, isn't it? So, when they passed the EB-5 Reform and Integrity Act, they said no new regional center filings for 526s sponsored by RCs for 60 days after enactment. So we're eagerly awaiting May 14th. However, then in the last 2 weeks, the USCIS posted on their website that every RC is no longer designated and they must file an application for new regional center status and new designation. So as many of you know, and I see in the Q&A, we're already getting questions about the lawsuit that was filed. Greenberg Traurig did file a lawsuit. The plaintiffs in that case were Bering. I'm not going to talk about the details, but we will be able to, hopefully hear soon on our request for a temporary restraining order. And, we are questioning whether they can nullify the way that they did 600 plus designated regional centers without doing what they're supposed to do under the Administrative Procedures Act. And we believe that it violates the statute and the plain language. I'm not going to go into the details of what was in the complaint. I hope you'll excuse me on that. But, I can't. So I do hope that we'll hear on that soon. I do think that it will be addressed on Friday by USCIS. Whether we're going to get clarity, in my opinion, I seriously doubt it. I think that they're going to say probably they can't comment on it because the lawsuit has been filed. And that is what I believe that they're going to do. There was a letter sent by IIUSA proposing that they revoke the guidance but issue a process by which regional centers can demonstrate compliance with the new integrity requirements and, show that the individuals involved in the regional center are willing to make attestations that they're good faith actors and that they will comply with the new integrity rules. But it's not clear at this time what's going to happen with the regional center designation. We also, need to think about further down the line, what does this mean for investor filings? Is it a way for them to push those out even further? In my personal opinion, I have a suspicion that it is.
Okay. All right, well, that's a downer, but it is what it is. And of course, as law publishers, I can assure you, we do not expect that you will discuss such matters that you're litigating on behalf of your clients. But if there is a matter of law and not specific to facts and circumstances that you feel comfortable discussing, we'd appreciate comments on that. And of course, Mark Katzoff is not similarly bound, I believe, on this specific case. And perhaps he might want to comment at his own discretion on that. So we'll see. Based upon the questions that are coming in, we have 4 or 5 questions already. That's terrific. 6, 7 questions. I'm sorry, and that's terrific. But let's continue. Let's switch to Mark. Securities compliance is a very important thing in the new EB-5 Reform and Integrity Act, and it apparently extends beyond just the offering documents. Could you please offer some comments?
Certainly. There are a number of instances in the Integrity Act that require a regional center to certify that their offering is being conducted in compliance with both the federal securities laws and the laws of the applicable states, without sort of necessarily specifying compliance with a particular law. And in addition, with the business plan for a particular project, the regional center is also required to submit a description of their procedures designed to ensure compliance with the securities laws. I think generally that any regional center that's gearing up to provide that certification, which again has to be done attesting that they've made the determination after doing due diligence, so there's some inquiry involved, should consider at least 4 relevant federal securities laws. The Securities Act of 1933, which generally would require registration of the offering unless the offering falls under a particular exemption. The Securities Exchange Act of 1934, which regulates broker-dealers, and both the 33 and the 34 Act also have provisions prohibiting the use of fraudulent tactics in offering securities. The Investment Company Act of 1940, which generally should not be a significant concern for the regional centers in terms of the structure of the offering, but if the offering isn't structured properly, that could require the EB-5 fund to register with the SEC. And the Investment Advisors Act, which is mainly a concern for the managers of the EB-5 funds. Excuse me. The main concern under the 33 Act in terms of finding an exemption is generally fairly simple for the funds, in that either it sells to accredited investors in the United States, or it's selling to investors outside the United States, which is obviously the predominant market, and is taking appropriate steps to avoid resale in the United States. Compliance with the broker-dealer rules, again, if you're dealing with registered broker-dealers in the US, is fairly simple. It can get more complicated when dealing with foreign agents or foreign brokers, again, where if they're not necessarily registered in the United States, and again, care needs to be taken that their activities are aimed outside the United States.
Okay. All right. Thank you, Mark, for those illuminating comments. I appreciate them. Let's go back to Kate. One of the exciting parts, if you forgive me to use that term, about this new statute is this new concept of set-asides. What are these? What are the implications of these set-asides, not necessarily for new investors, but how about for existing investors?
Sure. And that is something that I hope we will also get clarity on Friday, but ultimately we will get clarity once we get regulations, although that will take time. So just so everybody understands, visas under the new legislation are reserved each fiscal year. 20% go to rural, 10% go to high unemployment, 2% for infrastructure, and the unused reserves carry over to add to the reserves for the next year. But then the third year, the unused year goes without reservations. So the rural, I think, is going to be important to watch because we need to see if they will be filled up. You know, historically, I think there have been less filings, so that may allow for carryovers, but that will be something that's interesting to watch. I definitely think that USCIS should and will be asked, if they permit questions to be asked, about how this will impact existing investors. We've been fielding a lot of questions on it, and it is unclear. So we definitely need to see guidance on this.
All right, sure. We're all looking for guidance and, join the crowd. Absolutely. Let me now turn to Mark. The new act requires new agent registration requirements. What are the implications thereof?
Well, I noticed there was also a question in the chat related to this, particularly relating to the impact on broker-dealers who are also already registered with FINRA and the SEC, which is a very good question. I mean, as I read the bare bones of the act, this is should be a notice registration as opposed to any sort of substantive registration as is required by FINRA and the SEC, mainly providing contact information with respect to the agent. So my suspicion is that it should not be unduly burdensome on anyone who's already a broker-dealer in the US, as a lot of the information is publicly available via broker check anyway. It may be more daunting or concerning for foreign agents that may not necessarily be accustomed to doing any sort of formal registration, particularly one where the information might be available to the public. Again, as I said, at least at this point, barring regulations requiring something else, I don't think the actual filing is going to be particularly burdensome. One of the other questions I think relating to that is, again, the statute requires that the promoters as well as the regional center take steps to have guidelines for accurately representing the visa process to foreign investors and clear disclosure of their fees to investors. Again, anybody who's been properly operating EB-5 offerings up to this point, there's nothing there that should particularly be a matter of concern or anything that should be significantly different from the way they operate currently. But I think, regional centers are going to need to take a close look at the agreements they have with these agents in light of the Integrity Act to make sure that there are sufficient safeguards in place to make sure that the agents are complying with the requirements of the Act.
Very good. Thank you for the succinct summary. And, I think it's a very useful question because in other immigration contexts in other countries, this idea of dual regulation has come up. In Canada, for example, for a number of years, attorneys licensed to practice in Canada had not merely to maintain their law license, but on top of that, they had to qualify as migration agents under the then existing regulatory regime in Canada. And I believe for a short time, the same situation was the case in Australia also. So we just hope USCIS uses more of the common sense approach that you are advocating, and does not force a FINRA registered broker to go through something substantive, and that might be well beyond their scope anyway. In terms of their statutory authority. But let's take a pause here briefly for a short poll. And the idea is to learn from the poll. We have taken similar polls before and distributed the findings thereof to everyone in the EB-5 community. And we're going to do the same thing this time. We're going to see the results right away, of course. And then later on, we'll make it into a nice chart and distribute it to everyone. So if I can request technology to please launch the poll. It's just 3 questions and it's multiple choice. And it's designed to basically get an idea and a sense of the pulse of the industry. And as I said, we'll see the results together right now, and we'll also distribute them in the form of a nice chart to everyone later. What do you think is the size of the EB-5 capital market, the primary market, not the secondary market, not the redeployment market, the primary market, because of the EB-5 Reform Act? We give you a number of choices from under 500 million to over 5 billion. And could you please register one of the 3 that you feel is closest to your assessment of the situation? The second question out of 3 is, what are the number 1 and number 2 countries? Where will this new investment come from? And we've given you all kinds of multiple choices in terms of first and second. We've used what we think are the 3 biggest markets, but we could be wrong. So we've given a 7th choice, which is none of the above. And if you feel that you have a different sequence in mind or a different country in mind, you're welcome to choose none of the above if that's the closest to what you believe the market will be. So we are all trying to learn here, and maybe this might help us, all of us, get somewhere in terms of understanding what people think. And the last and final question is, 100% clarity sometimes is almost impossible in most fields, not just immigration. So 99% clarity is what standard we're using. And a lot of projects and a lot of attorneys are telling us that would be terrific to have. And of course, we don't have it today. We all have a lot of questions and not necessarily a lot of answers. So the idea is, when will we have that clarity? We give a number of choices in under 60 days and in over 3 years. And please go ahead and choose whatever you think is closest to your assessment of the situation. Lots of people have been responding. Roughly half the audience has already registered an opinion. I don't want to belabor this, and we want to spend time on learning from Kate and Mark, and also to address as many questions as you have sent. I think we have got about 16 questions, if I remember, if I can read correctly here. We'll try to address as many as we can. So I'll just pause for maybe 10 more seconds, 5 seconds, for anyone who is just struggling to finish the last radio button. May I encourage maybe the last 1 or 2 stragglers to please go ahead and complete what you want to register as your thoughts on these 3 questions. Going on soon. So 3 more seconds if anyone has a last minute addition. I still see 1 or 2 people coming through. Okay, 1 more person comes and they'll be the last one, and we'll call it a day at that point. So let's see, is there a last person coming through? Going, gone. All right, technology, let's terminate the poll and let's look at the results. And I'm going to just read them out for everyone, and the speakers are welcome to comment should they want to. In terms of what's the size of the capital market, there seems to be almost half the people are saying it'll be between $500 million to $1 billion. So that's a significant reduction, almost a 50% reduction over the market that existed in an average of 2017, 18, or 19. That's what apparently the folks in the audience think. In terms of where they will come from, everyone is all over the map. So some people think it's going to be USA first, China next. Some people think it's going to be India first, China next. And I mean, all the various choices, there seem to be their own fans of all the choices. There's, pretty evenly spread in terms of the choices that you folks made. And in terms of when will we have clarity, it seems like a 3-way split between 6 months, 1 year, and more than 3 years. So someone's going to be disappointed or someone's going to be super happy. Let's find out which. All right, so that's in a nutshell. Again, we'll distribute the results of these polls by our list and by Immigration Daily in due course. But let's return to our panelists. Back to Kate. Obviously, the new statute does leave some room for the agency to offer some clarifications in implementing the new law. What still needs to be clarified? Would you please comment?
Sure. So I'm going to do this also in conjunction with some of the questions that have been asked. So clearly they've grandfathered past filings. We are filing adjustments for people who have 526s pending. And I will tell you that we have gotten receipts already for those. So the agency is accepting them. Likewise, we do have notices at multiple consulates now from consulates and the NVC. The NVC is processing cases and we do have appointments scheduled. So that is good news and they are proceeding. In terms of the grandfathering, I think we need clarity on how the applicants in line now are going to be impacted by the set-asides. I understand generally how they work. I understand the goal of the legislation, but there is a fairness aspect that needs to be addressed with people who have been in line. And how will that, impact them in terms of timing? That really needs to be clarified. There's a lot of concern, particularly when people are from China. In terms of the integrity requirements, we are advising clients that they will now be subject to the integrity requirements and that they will need to meet them and comply. So I want to be clear on that. In terms of new projects, so I think that it's pretty clear in the new law that they say that a regional center must file an application for project approval in order to move forward. It doesn't need to be adjudicated before 526s are filed, and thank God for that, because everything seems to be taking so long these days. And I also think they're probably understaffed and wouldn't be able to adjudicate anything quickly. As we know, we have 8 to 9s pending. And the project requests have to contain the documents they've typically contained, right? So they have to have offering documents. They have to have an immigration template. They're going to have a jobs report. But now, obviously, they'll have to include some of the information that Mark was talking about, fees paid to marketing agents and brokers. They'll need to certify and describe their securities law compliance and who they're working with in that regard. I think that it'll be interesting to see how the regional centers maintain compliance when distributing templates to investors, because yes, the project has to submit for pre-approval, but a lot of this information is also going to have to be included in the individual investor petitions, has to be disclosed to them, and it needs to be included. And I think many of us who have represented regional centers or reviewed filings put together by other attorneys, we know that not everything always makes it into the file. So it'll be interesting to see how they implement a review process. It may be that many regional centers want their counsel or their in-house counsel to review 526s filed through the RC to make sure that they're hitting the compliance requirements and using the template that they've created. The new legislation also says that project requests can be amended within 30 days after changes and that are identified in the agency's guidance. So I don't, it's going to be absolutely a requirement that everybody has to file for a new project pre-approval. Obviously, the laws changed. You can't use the old documents. And in fact, we have projects just in a holding pattern right now for both immigration and securities corporate work until we get more substantive guidance. And so we can draft things appropriately, because undoubtedly we'll end up rewriting them. It's also interesting that as part of these new filings that USCIS is going to perform a site visit to each project with 24 hours notice. And I think that's a good thing. I think that we also need some clarity on the redeployment. So, the bill recognizes redeployment of capital and it permits it, and it, allows it to meet the existing requirements in the old law, but it also expanded it to allow that the redeployment can occur nationally. But the thing that I found really sort of shocking in the new law was that the USCIS requires a termination of the regional center if any of the new commercial enterprises violate the redeployment requirements. So we'll need to see how that's interpreted and how strictly it's administered, because that could have serious implications for people wishing to redeploy. And, you know, likewise, what about a scenario where the project may have been partially successful, a part is repaid, a part isn't repaid? How are they going to handle that? How are they going to interpret that and adjudicate that? I think that remains to be seen, and we need clarity.
Wonderful, wonderful. Thank you, Kate. A lot to chew on there. Let me turn on part of what you touched upon to bring it before Mark. There's a lot on redeployment in the new statute. And in particular, the geographic scope is now relaxed. What are your thoughts on that, sir?
I mean, that I think is one of the good pieces of news that comes out of the act. And we're actually, it's something that is less restrictive than the existing standards, although as Kate noted, that sort of comes with the potential punch of, if you don't comply with redeployment standards, there could be significant consequences. But again, you know, under the old rules, redeployment was restricted to the geographic area of the original project in the area within the scope of the regional center. And now under the new statute, redeployment can be nationwide, which really makes sense when you think about it, given that the requirement is that you've already satisfied the job creation, and therefore you served the primary purpose of EB-5 in the first place. So the main need for redeployment is to keep the investment at risk. So it makes sense that the standards for that should be somewhat relaxed. And with that, so I don't have much else to say on the topic. I want to save some of the time for some of the very interesting questions that have been posed.
Terrific. We're going to turn to the questions in a moment. Two quick reminders to folks. Our speakers did weave in answers to some of the questions already. So that's going to make the question answer session much more productive and efficient. So we're going to probably be able to handle more questions. So go ahead and register your questions. The bottom of your screen where it says chat or Q&A. Q&A is preferred, but if you want to do chat, you can do that too. I'm tracking both of them on my second screen here, and I'll be sure to bring them up for the comments from our distinguished panelists. Secondly, I do want to, my colleagues are reminding me for our last and final advertising break, we're going to pause for 30 seconds. Shrikant, take it away.
Thank you, Sam. We are noticing a significant pent-up demand for EB-5 from reports of multiple agents from multiple countries, and also at our USA events. We have events coming up in Mumbai, Kuwait, Phoenix, and Atlanta, all between May 19th and May 22nd. To exhibit and speak at these events, you can reach us at webmaster@ilw.com. Thank you.
Thank you, Shrikant. Thank you. All right, so let's plunge into some of these amazing questions that are coming in. I'm going to try to do them as much as I can in the sequence that they've come in. And of course, we must bear in mind that one of our speakers may feel that some things are sub judice, and therefore she has a duty to remain silent on those. That should not be construed to mean that she doesn't have an opinion, or a very intelligent opinion, and probably a very enlightening opinion, but we will excuse her naturally, because she cannot comment on things that are sub judice for her clients. Let me now plunge in. Let's see. Interesting question just came in. If the reauthorization, let's say a regional center no longer wants any new I-5 26 investors. They are happy with what they've raised. They're busy deploying that capital in the projects that they have already undertaken, and they have no plans for raising any new capital. Does such an RC need to get, quote, reauthorized, quote, recertified, or quote, redesignated? Any thoughts?
That's a really good question and a very thoughtful one. And I think we're going to have to see the outcome of the lawsuit with respect to the definition of reauthorization. Presumably, their investors are going to be grandfathered, and their petitions will be adjudicated. And I think that's part of why this policy that USCIS just posted on the website is very short-sighted and doesn't make sense. But I do think they will be grandfathered. I think they should be protected. But, you know, let's see. I think it remains to be seen. And I do want to tell you that there is going to be a hearing on the temporary restraining order next week. So, you know, stay tuned for updates on that.
Well, hopefully that means that, you know, federal judge will read the law and perhaps help USCIS read the law. And that's a good thing. You know, that's why they build the courthouses. They say sometimes you have to go to it. You know, unfortunately, USCIS forces us to go there more often than anyone should, but such is the agency that we are saddled with. Mark, if you don't have any more comments on that subject, I can proceed with the next question. Shall I go ahead?
Yes, please.
Okay, so this question has been, I think, in part answered, but I think it's well phrased, so I'm going to repeat it very, very quickly in a sentence or so. Are you folks, the two of you, advising your clients that they will need to file new applications for NCE designations in other words, even if the project previously received a 924 exemplar approval, or do you advise that's not needed? Continuing along the same theme, are you advising your previously designated RC clients that new integrity measures apply to them, or do they not? Any thoughts on that set of questions?
I think the answer is yes to both. They're going to need a new project pre-approval. That's a requirement. And the requirements are different, right? So we have to prepare new documents no matter what. So definitely yes. And then yes to the second question, we are telling them that the integrity measures will apply to them going forward.
Okay. Mark, you're welcome to agree or disagree if you want to. I mean, it doesn't have to be one answer for.
Certainly. I'm, again, just for the benefit of the audience, since my primary focus is on the security side of EB-5, I'm happy to defer to Kate on most of the more immigration-related questions. With respect to the second part of that question, I do definitely agree that we're also advising our clients that the existing regional centers will have to comply with the integrity measures.
Perfect. Thank you. Thank you. Appreciate that. And yes, we do understand your practice is limited to corporate securities law, and that you know, you limit your comments in terms of anything that requires expertise in immigration and nationality law. That's a very good point. We have a question which says that for applications that were already filed previously, let's say a year or 2 or 3 years ago, is concurrent filing for adjustment of status now available? Can people file an I-485, a 765, an I-131 for 526 that went in many years ago? Any thoughts?
Yes, if they are in valid status in the United States, they can now file for an adjustment, and of course the corresponding 765 and I-131. I do want to say we've seen a trend in other filings, in other immigration filings, where we have some 765s and 131s that are pending 12 months, 18 months, and we don't have decisions on, and we have others that are being approved in 5 to 6 months that are more recently filed at the start of 2022. Or, you know, just at the end of next year. So this first in, first out thing with the agency, I don't know what's happening with that, but it's clearly not being applied. But yes, they can concurrently file if they're here in valid status. Okay. And I also, I want to piggyback on that because somebody's asking about B2. So obviously, you can't have the intention to enter on a visitor visa and file an adjustment, but intention can change. And so we will be filing and are filing adjustments for people who have entered as visitors after 90 days.
Okay, very good. This question is for Mark. And of course, that doesn't mean Kate cannot jump in if she wants to. Could you please elaborate on how EB-5 funds can be raised as a 506C offering? What are the benefits thereof? What are the limitations? How does it compare with other types of offerings? Any thoughts on that?
Certainly. So the difference between a 506C offering and other forms of offerings under 506 is that 506C allows for general solicitation. So in part, the benefits depend on how much of the investor pool a fund is anticipating drawing from investors already within the United States as opposed to outside the United States. The one main compliance restriction between 506 and other forms of 506C and other forms of 506 offerings are that you need to take additional steps to verify the accredited investor status of the investors. And I actually have always thought that EB-5 is sort of the perfect realm for that because of all the verification that needs to be done for sources of funds and the like. So I don't see a significant downside in using 506C if, again, a fund thinks it's going to have a substantial US market or wants to have greater flexibility in terms of how they market the fund to investors within the US.
Okay. Thank you. And this is great. Lots of questions are coming in. You can continue to register your questions, and I think we have another at least 5 or 10 minutes. We're going to try to handle as many as come in. Please go ahead and register them. I'm taking them more or less in the sequence that they came in the Q&A box down at the bottom of your screen. This questioner says, Kate and Mark, thank you so much for being on this panel. It's wonderful to see you both. And then they ask a question. I'm going to paraphrase it. I think it was answered, but perhaps you could re-clarify. A RC with projects for which the business plan was approved under the prior statute and prior regulations, do they not have to comply with the new integrity requirements? Do they have to comply with the new integrity requirements? Could you clarify again?
So the position that I think that we're advising clients on is new projects will need to comply with the integrity requirements. And if you're going to continue raising money for a project that was in the middle of a capital raise, you will need to create new documents. You will need to meet the new requirements.
Okay. I hope that's clear. I know this question came up in 2 or 3 different forms.
Obviously, everybody is going to have to make the annual compliance filing, right? Which is this is going to be very robust now. It's going to require more time from us as the immigration attorneys, but also from Mark and his counterparts in corporate securities, because we're definitely going to need more information from them. And I saw there was a later question about forming compliance teams. Well, this is really going to be the new frontier of EB-5 practice, because compliance, and I think it's a good thing, is a major part of the new law. And they want to make sure that integrity requirements are in place. So I think many of us have dealt with regional centers who have had poor record keeping practices, who may not have insured, or checked the overseas agents so stringently, who also may not have kept records well for people in the US because maybe they didn't have enough staff, maybe they were overwhelmed, whatever, they weren't required to, but now they are. So it's going to be very important, to get a lot of moving pieces in place to have a team who's going to advise them. And Mark can probably jump in here, but you're going to need a fund advisor. You're going to need, an accounting firm who can also comply with the accounting requirements. They're also, quite in depth in the new legislation. So there's a lot of moving parts here. And I'm sure, Mark, you want to add to what I'm saying?
Yes, and I generally agree with what Kate was saying. I think sort of another part of that, or a related question I saw, had to do with, are there any sort of existing guidelines that could be drawn upon in terms of developing the procedures for regional centers? And I'd say, one place to look are broker-dealers and investment advisors, both of whom have been registered with the SEC, have generally been required to have a very robust set of compliance procedures. Not everything that they're required to do are going to be required at the regional center, because there's some very specific requirements that would only relate to their own practices, but at least it's a potential area to look at in terms like verifying the information about the project to ensure compliance with the anti-fraud procedures, or in ensuring that the offering is being constructed in a way to fall within one of the exemptions from the securities laws.
And there's a lot of interesting questions I feel like that arise out of the new requirements. So say, for example, the agent registration. What if you worked with an agent who now doesn't want to register, but contractually, say the 526 is now approved and you owe them the second installment? How do you pay? And they're not registering with the USCIS. Or what about an agent that, I don't know, some we've heard stories of some who may have gotten inquiries from the SEC or from their local securities, regulators. How is the USCIS going to make a determination whether they meet the requirements when they get that information? I don't even know that they even have the standards to adjudicate that. It's so outside of the purview of what they typically do.
Wow.
My own hope is that they're not going to do a lot of substantive review and audit of the agents, because that really is something that's outside their area of expertise, is more an SEC issue, and that their focus would be sort of more on notice and disclosure. But again, that remains to be seen. All the detail is ultimately going to come as the rules are actually developed. And I think that there was another question in there about, given the registration requirement, can you pay agents at this point before they're registered? And I think the answer to that is reasonably yes, because basically the statute provides the framework for USCIS to develop the regulations regarding registration and the like. But until they've actually established the requirement, I think you can probably operate to a degree under the old scheme. Now, in terms of the question that Kate raised of, how do you deal with agents who have existing agreements and who wind up out of compliance once the new rules apply? Generally, when I'm drafting the agreements with the foreign agents, we try to build some form of out clause of they're only entitled to the payments to the extent that the fund is legally entitled to pay them. So a scenario where, there are requirements to register the agents, and it's clear that that would apply to agents who are getting the tail on an existing project, then if you've got a clause like that built into the agreement, I think the funds get pretty good leverage to say, either you register or we're not going to pay you. And even in absence of such a clause, if you get a situation where the agent is going to say, we're going to sue you, they're not in a particularly good position if they're going to attempt to sue, and you've got a credible argument that paying them would be prohibited under the new law because they're not registered. As I say, usually we try to build in a few fail-safes of requiring them to act to comply with the applicable laws for exactly this reason.
Sure. So, hopefully force majeure does not have to be resorted to, but sometimes you have to. I hear you loud and clear. Question for Kate. Some immigration counsel believe that the sustainment throughout the conditional LPR period will not be required under the new law. Do you have any thoughts on that?
I think this is something that will need to be clarified because they did specifically address redeployment, so it's not very clear. And unfortunately, regulations are going to take a while, right? I mean, the agency doesn't move quickly, then they're going to have to allow for notice and comment. In a best case scenario, I think we're like a year and a half out from those. But it's a good question.
Yes, lots of good questions, and sometimes there aren't any good answers. And that's just the nature of the situation we're in. So please don't blame the panelists. They're telling you as best as they understand what the state of play is. There's a question for me, so I'll address it. The questioner wants to know if the recording of this event will be distributed. Yes, absolutely. This is going to be up on our YouTube channel in a couple of days. Give us at the most until Monday next week, and we'll be sending links to that recording to everyone. You can subscribe to our YouTube channel also if that's something that you want immediate notification of. Now, let's see. I think we have time for probably just one or two more. Let's see. Let's see. There are a lot of specifics, and I'm trying to select questions which are of general interest. There's a lot of questions about what you can do as a tourist. I'm going to skip those for now.
Sam, I like the last question for Mark. I think it's a good one.
Okay.
About whether agent registration and fee disclosure requirements will make an industry standard.
Right. Any thoughts on that, Mark?
I mean, I certainly think that it would be a good idea, and given that there are going to be significant, at least we're hoping if USCIS drafts the regulations properly, there'll be some clear standards. So I think it will then drive a move towards more standardized agreements. Now, the other half of that question I saw was whether that's going to lead to agents asking for less in fees, and that I don't anticipate happening, because the size of the fee is not going to impact the requirement that they register or the requirement that they disclose. Now, is there an outside possibility that if they need to disclose them very clearly, and there's actually, a requirement somewhere in the statute that unless it's otherwise disclosed in the business plan filing, that each individual investor petition, I believe, needs to include disclosure signed by the investor setting out all the fees they're paying. So it may be with Sunshine that the agents get some pushback from the investors, but my suspicion from what I've seen in the past is that's probably not the case, and that the investors view that as part of the price of getting the green card.
Well, of course, the market will tell. The limited data that we have seen coming in from foreign agents is that many of them are really reluctant to have those kinds of disclosures to their investors. We have seen that from multiple agents in multiple countries. But again, the market will speak, and I think all we have is anecdotes. Anecdotes are not data. So let's wait for some data. All right, we're going to take one last question, and that is, do the requirements that's in this new statute that specifically reference implementing regulations, such as, for example, limits on bonds or limits on foreign involvement, not take effect before the regulations are finalized, or should we presume they are now in effect? Any thoughts?
So I think that's a really good question, Suzanne. And I want to say you've had amazing questions today, very thoughtful and very detailed. This is my opinion. I think the answer is we will need regulations. USCIS presumably will issue guidance. I think that if it's outlandish, it will be challenged. And it should be challenged because it's not regulation.
That's right. Policy guidance is not regulation under the four square corners of the Administrative Procedure Act. So, it's a good idea, as what Kate suggests, that the agency should act reasonably and fairly. And if it doesn't, then unfortunately, sometimes we have to use the stick and not the carrot. So that's just the hand that all of us in the industry have been dealt, and we have to handle it as best as we can. So now, thank you, everyone. We have strained our courtesy of our panelists long enough. I am very happy to say that we answered a lot of questions today, and not as many unanswered questions today as there were before. We'll continue to hold these from time to time. They're always going to be free. We hope that that helps people in the industry stay on top of what's happening. We're certainly living at a tumultuous time in this industry, and hopefully one that will lead to a cleaner, bigger, better, and fairer industry for all participants. So with that hope, I want to once again repeat our reminder to everyone to remember, this is, we are all bound by American law. This is not legal advice nor financial advice. It is educational material. I hope it has given you some food for thought. And with that, this is goodbye from ILW.com.